Good afternoon, Chautauqua. Good afternoon. What a gorgeous day here on the Grove. We're so glad to see you all. My name is Jordan Steves. I serve Chautauqua Institution as Emily and Richard Smucker Chair for Education, and it is my pleasure to welcome you to the Hall of Philosophy this afternoon as we continue a beloved tradition with the 22nd Annual Robert H. Jackson Lecture on the Supreme Court of the United States. Since 2005, Chautauqua has been delighted to host our friends and neighbors at the Robert H. Jackson Center in nearby Jamestown as they bring the best Supreme Court scholars of our time to Chautauqua. These scholars have helped us each year unpack the most recent court term and have provided insight on the state of the court in general. I will let my colleague John Q. Barrett give a more fulsome explanation of the history and purpose of this program in a few moments, and I also want to offer a warm Chautauqua welcome to our special guests from the Jackson Center who are joining us today, including President Kristen McMahon and our interns for this summer. Welcome. In addition to our in-person audience here in the Hall of Philosophy, we are pleased to welcome those of you watching and engaging with this program on our Chautauqua Institution YouTube channel. Thank you for joining us. All of you who are with us live are welcome to participate in the Q&A at the end of the program. You can submit questions at any point during the lecture via our question portal at questions.chq.org. Our Hall of Philosophy audience here in person may also submit handwritten questions, which will be collected by the ushers and education staff after the lecture concludes. And finally, out of respect for our guests on the dais here and your fellow audience members, please take a moment, reach into your pocket, pull out that phone, and just make sure it's on silent so we can enjoy our time together. Thank you. I'm honored this afternoon to welcome back to Chautauqua our friend John Q. Barrett. Professor Barrett is the Benjamin N. Cardozo Professor of Law at St. John's University in New York City, where he teaches constitutional law, criminal procedure, and legal history courses. He is also the Elizabeth S. Lennay Fellow and a former member of the Board of Directors at the Robert H. Jackson Center. Professor Barrett is writing a biography of U.S. Supreme Court Justice and Nuremberg prosecutor Robert H. Jackson. This work will include the first inside account of Justice Jackson's service by appointment of President Truman as the chief prosecutor at Nuremberg of the principal surviving Nazi leaders following World War II. And I will note, for those of you who are interested, Kristen and I are leading a trip to Nuremberg in September through our Chautauqua Travels program. So if you're interested, there are a few spots left, and you can visit travels.chq.org. In the meantime, please help me give a warm Chautauqua welcome back to Professor John Q. Barrett.
Good afternoon, friends. Thank you, Jordan and Chautauqua Institution, the Robert H. Jackson Center, Arnie and Jill Bello, whose support makes this lecture possible, and all of you. This is my 26th consecutive summer of getting to speak on a Chautauqua platform, and it is a real treasure. It is a delight to be back here. My role today is to address three topics: Robert H. Jackson, the lecture, and the lecturer. First, with regard to Jackson, let me take you back 80 years to the day. Saturday, July 27, 1946. Robert H. Jackson, then age 54, was a U.S. Supreme Court justice. He was the U.S. chief prosecutor in Nuremberg in occupied former Germany. He had the day before delivered his closing statement in the Nuremberg trial. And so on this July 27th, he was back in court in a spectator role, listening to his fellow chief prosecutors deliver their closing statements. And I think that Jackson was doing three other things. First, he was experiencing exhausted relief. He had been over a year away from the U.S. Supreme Court doing this first international criminal trial, and it was a big lift and a perilous proceeding, but it had gotten to his closing statement. Second, I think he was, with some pride, feeling the substance of what they were doing there at Nuremberg. They were building law, they were promoting peace, they were valuing human equality, and they were seeking justice. And all of those are fundamentally valuable, deeply valuable, and I think they must have been gratifying. And third, I suspect that Jackson was longing for home. And I don't just mean the United States, I mean here, Chautauqua Institution. Because in 1946, for the second consecutive summer, he was away doing this assignment and not getting to his beloved Chautauqua. Jackson, you see, was a Chautauquan. He was you. From his boyhood, these grounds, these not microphones, but projection speakers, were part of his education. As a boy, he heard William Jennings Bryan speak here a number of times. And for his full life, absent those 2 years, Jackson came to Chautauqua and treasured those experiences. He was born in 1892 below the state line in Spring Creek, Pennsylvania, on a family farm. The family moved up into New York State, and he grew up in Frewsburg, a little town south of here. He then, after graduating from the Frewsburg High School, went to Jamestown High School and became a Jamestown law apprentice. He got his legal education at Albany Law School, and at age 21, he became a member of the New York Bar. And then, over 20 years in private practice, he rose to excellence. A lawyer in Chautauqua County, recruited to be a lawyer in the big city of Buffalo, back to be a law firm leader and a bar leader based in Jamestown, and a rising power in regional and New York State and national private legal practice. And Robert Jackson also had some politics. He was a Democrat by family heritage, and that meant as a young man he met a New York State senator from Dutchess County named Frank Roosevelt. And in time, that fellow filled out and rose to higher positions. So in 1928, when he's running for governor, FDR draws Robert Jackson in as a proxy speaker. And during the 4 years when Roosevelt is governor, Jackson doesn't go to Albany for a full-time job, but he is an appointee on task forces and special projects and a big Roosevelt supporter. And then, of course, Roosevelt is a presidential nominee. In 1932, Jackson is a proxy speaker, and Roosevelt wins. So now our kid, Bob Jackson, has a friend in the White House. And so FDR 5 times nominates, and the Senate confirms Robert Jackson to senior positions in Washington, D.C. 1934, General Counsel of the Bureau of Revenue in the Treasury Department. 1936, Assistant Attorney General in the U.S. Department of Justice. And he had 2 jobs in that title, first heading the tax division, then heading the antitrust division. 1938, appointed Solicitor General of the United States. We'll come back to that. 1940, appointed Attorney General of the United States. And 1941, appointed an Associate Justice of the Supreme Court of the United States, when he is all of 49 years old. Now, let me return to the 1938 through 1940 job, then the number 2 position in the Justice Department. Solicitor General of the United States is the defender in court of the interests of our country. That includes, in the apex role, advocating the government's position, defending statutes, defending federal interests in the Supreme Court of the United States. Robert Jackson loved this job. He thought it was a lawyer's dream job. And he was very, very good at it. He rose to be one of our very best solicitors general. And he argued and he won vital cases. Perhaps at the top of the list is successfully defending the constitutionality of Social Security. But after 2 years in that position, he couldn't avoid being promoted. And after 18 years as Attorney General, he was sent to the Supreme Court, if you will. And over the next 4 years, he became Justice Jackson, doing independent thinking, independent judging, beautiful writing, authoring landmark decisions, and rising to a leading stature as a judicial figure in the United States. In 1945, he's interrupted from that job by a 6th presidential assignment, which is President Harry Truman, the new president, needing to fill the role of the United States at the commitment that the Allies, once they won the war, would hold the Nazi perpetrators accountable. And so Truman reached for America's leading legal figure, which was Robert Jackson, and sent him to first London and then Nuremberg, which caused Jackson to miss a full year of the work of the Supreme Court, AWOL, if you will, and to do the chief prosecutor job at Nuremberg. producing convictions, producing an evidentiary record, producing a historical legacy of legal development and accountability on those topics I itemized earlier. And then Jackson returned to the Supreme Court in 1946. He lived 8 more years. He was part of momentous decisions. The top of the list is Brown versus Board of Education. But perhaps most important, in the summer of 1947, Robert Jackson resumed coming to Chautauqua. Indeed, on the 4th of July, 1947, he gave a major address in the amphitheater in that time when the Cold War was really starting to become a terrifying reality. That was a reassurance from somebody who had worked closely with Russians and had optimistic things to say about the future of this country. Second topic, this lecture. The Robert H. Jackson Lecture on the Supreme Court of the United States obviously takes that Supreme Court advocate and Supreme Court justice and revered author of Supreme Court opinions and makes him a moniker for an opportunity to study every year in this nice little seam after the Supreme Court has begun its summer recess, the stature, the status, the work, the place, and the significance of the Supreme Court in our lives. Topic 3, the lecturer. Michael R. Dreeben is a native of New Jersey, a graduate of the University of Wisconsin, a graduate of Duke Law School, somebody who briefly gave a shot to private law practice and it didn't work out. Instead, he went to the U.S. Department of Justice. He went to the Office of the Solicitor General of the United States, Bob Jackson's old office, as first an assistant to the Solicitor General in that small office, one of the line attorneys, if you will, and then promoted to a deputy position, and over decades becoming our country's expert specialist, including in the Supreme Court, on criminal law. Michael argued over his career 109 cases in the U.S. Supreme Court. Bob Jackson, about 50. Michael Dreeben, 109. Michael left the Department of Justice, again, briefly gave private practice a crack, and then got recruited by Robert Mueller when he was special counsel to handle legal work in the Mueller special counsel investigation of Russian interference in the 2016 election. And at an interval after that, Michael was recruited by special counsel Jack Smith to come back into the U.S. Department of Justice to handle legal issues in the criminal case brought against former President Donald Trump relating to the 2020 election. Michael Dreeben's most recent Supreme Court argument occurred in spring of 2024. That was Trump versus United States, the criminal immunity case. I commend 2 resources to you and to history. First, listen to the audio of Michael Dreeben's oral argument. You'll hear the justices doing what the justices are doing as questioners. You'll hear brilliant advocacy from Michael's side of the podium. Second, and comparatively, look at the text of the decision that the court rendered a couple of months later in July 2024. I think the comparison will pull you in a direction. These resources illuminate why I am glad that Michael Dreeben was my and the people of the United States lawyer in that case. He today teaches at Georgetown Law School, at Harvard Law School, at American University Law School. And it's really an honor to welcome him as Chautauqua Institution's 22nd annual Robert H. Jackson Lecturer on the Supreme Court of the United States.
Thank you very much, John, for that incredibly kind introduction. Thanks to all of you for coming to the 22nd annual Robert H. Jackson Lecture on the Supreme Court. This is my first time at Chautauqua, and I certainly hope I learn to pronounce it before I leave. It's really an honor to speak to you in this setting about an institution, the Supreme Court, that Robert Jackson served with such distinction, as you heard, and that has such a profound impact on our lives and the life of the country. Robert Jackson was perhaps the most eloquent of all Supreme Court justices. He had a gift for conveying complex thoughts with arresting images fused with down-to-earth candor and directness. And this is particularly impressive since, as John explained, he had no formal education beyond high school except for 1 year in law school. Perhaps that absence of legal training contributed to Justice Jackson's ability to cut to the heart of the issue. So I will try to unlearn things that I learned in law school for the purposes of talking to you. One of the things that Justice Jackson did so well was to encapsulate ideas with memorable quips. And one of them was a comment that he made about the Supreme Court. He said, "We are not final because we are infallible, but we are infallible only because we are final." And what Jackson meant by that was really an ironic point. He knew that the Supreme Court was neither infallible nor final. The court often admits error and overrules past decisions that it regards as mistakes. And when it does not correct itself, the people of the United States, you, can correct the court by electing legislators who will pass laws that will reverse Supreme Court statutory decisions, or in rare instances, amending the Constitution itself. It's well to remember the Supreme Court's potential for fallibility and the chance for correction at times like these, when the court's decisions can engender intense controversy. In talking about this past term Supreme Court's decisions, my theme is equality in the law. It's appropriate to talk about equality 250 years after the Declaration of Independence began with these stirring words: "We hold these truths to be self-evident, that all men are created equal." The Supreme Court's monumental building in Washington, often called the Marble Palace, almost as magnificent as the space we're in right now, reflects that ideal. Carved into its pediments are the words, "equal justice under law." The past Supreme Court term defined equality in several important cases. These cases touched on a long-running theme in American jurisprudence. Who counts in America? Not only what it means to be an American, but also who in America gets to participate fully in civic and political life. The court has at times addressed these issues in uplifting and inspiring ways. A shining example is the court's 1954 decision in Brown versus Board of Education. There, the court unanimously ended racial segregation in public schools and ushered in an area of increased protection of civil rights for all Americans. As it turned out, Brown was the last significant opinion that Robert Jackson joined before his death in October 1954. But at times, our court has defined what it means to be an American in far less noble ways. The low point in the court's history was its 1857 decision in Dred Scott versus Sanford. To its disgrace, the court there held that African Americans could never be citizens of the United States. It took a civil war, 600,000 dead, and 3 constitutional amendments to overturn Dred Scott. Last term, the court issued 3 decisions that together contribute to its ongoing project of defining what it means to be an American. All 3 decisions interpreted these post-Civil War amendments, and they sought to implement, in some respects, the aim of those amendments to create a more inclusive and more equal America. The first decision that I'm going to talk about is the court's reaffirmation of birthright citizenship in Trump versus Barbera. That decision honored the 14th Amendment's gift of providing to all Americans born in this country the right to become a citizen. But 2 other decisions that I will discuss paint a different picture of equality. Citizenship, John Roberts wrote in Trump versus Barbera, is the right to have rights. Citizenship is thus the gateway to equal rights in this country. But once citizens are admitted to this city on a hill, the rights available, the Supreme Court has told us, turn out not to be so equal for all. First, the birthright citizenship case. Here, the court interpreted the majestic language of the 14th Amendment's opening phrase, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. This provision directly and emphatically rejected Dred Scott by affirming citizenship for all persons, regardless of race, who are born in this country and subject to its authority. These sweeping words offered a broad promise of citizenship, excluding no class or caste. In an 1898 case, United States versus Wong Kim Ark, the government argued nonetheless that birthright citizenship did not apply to the son of non-citizen Chinese parents living and working in San Francisco. Although the son, Wong Kim Ark, was born here, the government sought to deny his citizenship because his parents were Chinese citizens. The Supreme Court rejected that narrow reading. It interpreted the 14th Amendment as virtually universal in its application, giving citizenship to all people born here with 3 exceptions: children of foreign diplomats whose allegiance is to their country, children born in lands under enemy occupation, which was a realistic issue in the 19th century, not so much today, we hope, and children of tribal Indians who were members of what the court regarded as an interior domestic dependent sovereign that had its own aspects of sovereignty, even though in the United States. Everyone else born here became a citizen by birth, became part of the American community as a matter of constitutional right. And Congress later made tribal Indians citizens by statute. The court's holding in this case represented that the United States is a land of immigrants. I'm sure if we went around the room and talked to where people came from, we would have countries represented from all over the world. There, the matter of birthright citizenship stood until 2025. In January of that year, President Trump, at the beginning of his second term, issued an executive order prospectively denying birthright citizenship to children of parents temporarily or unlawfully in the United States, claiming that such children did not acquire citizenship under the text of the 14th Amendment. The president's order was immediately challenged as unconstitutional, and as most of the pressing, divisive social issues in our country do, it came before the Supreme Court. In a decision issued on the last day of this current term, June 2026, Chief Justice Roberts wrote for a majority of the court that President Trump was wrong. In soaring language paying tribute to the United States as a nation of immigrants, the court held that the 14th Amendment Citizenship Clause made no exception for the children of parents unlawfully or temporarily here. The United States, the chief wrote, quoting Thomas Paine, is an asylum for mankind. Birthright citizenship is among the things that define what it means to be an American. The court's decision can be viewed as a judicial statue of liberty, a welcoming beacon to those born on our shores. Particularly notable was the court's rejection of the legacy of Dred Scott. Chief Justice Roberts emphasized the repellent racial taint animating that decision, which created a caste of people forever locked out of participation in our national life. But as the chief wrote, the people, eventually, you, would overrule the court. After the Civil War, the Reconstruction Congress first enacted the Civil Rights Act of 1866 to bring all persons within birthright citizenship, and the nation soon ratified the 14th Amendment to enshrine birthright citizenship in the Constitution. The goal of this amendment was to put the question of birthright citizenship, quote, beyond the legislative power forever. Now, you may be wondering, why was any of this open to serious debate? The Constitution's text, the repudiation of Dred Scott, the precedent of the Supreme Court in Wong Kim Ark all pointed to a single conclusion. As the Chief Justice wrote, a child born on American soil and subject to American law was made an American citizen. But the clarity of those sources could not erase a dark undercurrent in American thought, resistance to sharing the blessings of citizenship to those people who are outside the mainstream. This was a thought that never truly faded from national discourse. Few people took this legal challenge seriously until recent years, but then it gathered enough steam to produce President Trump's executive order. And here is the shocker. On the constitutional question of what the Citizenship Clause of the 14th Amendment means, the court was split 5-4. Only 5 justices confirmed the constitutional basis for birthright citizenship. 4 justices, adopting 4 somewhat different legal theories and readings of history, dissented from that view. The shift of a single vote could have upended this deeply settled tenet of our national identity. Fortunately, that did not occur. The Chief Justice used all of his legal and rhetorical powers to write a decision that I think will echo through history. He reaffirmed that in the Citizenship Clause, the framers of the 14th Amendment saw emancipation. Citizenship, he explained, is the right to participate freely in our political community. The drafters of the 14th Amendment extended that promise to birthright citizens, and the court said, we keep that promise today. Of course, as Justice Jackson reminded us, the court is not really final. Its decisions are not immutable. The Trump administration has in fact vowed, in a bold move, but one almost certainly destined to fail, to ask the Supreme Court to rehear and reverse its birthright citizenship decision. And the House of Representatives is considering bills to overturn the court's constitutional holding, which of course the legislature cannot do. So the birthright citizenship was good news on the Supreme Court. But 2 other of the Supreme Court's decisions cast in a different light the meaning of the right of citizens, in the court's words, to freely participate in our political community. These 2 cases interpreted the 14th Amendment's Equal Protection Clause, that no state shall deny equal protection to any person within its jurisdiction. One of these cases also applied the 15th Amendment's provision that the right of citizens to vote shall not be limited or abridged on the basis of race, color, or previous condition of servitude. So the cases that I'm about to discuss interpreted constitutional language interpreting our highest ideals. But in these 2 cases, the message is more sobering. Being part of the American political community does not prevent a state from locking you out of full participation in civic and political life. The first of these cases is Calais versus Louisiana, and it involves the Voting Rights Act of 1965, which I'm sure many of you remember when it was enacted. Justice Kagan wrote in her dissent that the Voting Rights Act was one of the most consequential, efficacious, and amply justified exercises of federal legislative power in the nation's history. She explained that it was born of the literal blood of Union soldiers and civil rights marchers. It ushered in awe-inspiring change, she said, bringing this nation closer to fulfilling the ideals of democracy and racial equality. Yet in Calais, the majority gutted the ability of plaintiffs to use the Voting Rights Act to achieve greater equality in voting. The court took one of the crown jewels of the civil rights movement and rendered it virtually toothless. Now, the facts of this case are complex and technical, so I hope you bear with me as I try to unpack what the court actually did in this case. First, let's begin with Louisiana. It has 6 congressional seats, and its population is approximately 1/3 African American. After the results of the 2020 census, Louisiana redrew its congressional district lines. The state's districting map continued its historic practice of drawing only one district, embracing New Orleans, with an African American majority, otherwise spreading out the remaining African Americans into 5 districts that had a majority of white voters and that consistently voted to elect white candidates. Now, neither the Constitution nor the Voting Rights Act guarantees proportional representation on the basis of race. That is not what this country stands for. But the Voting Rights Act was enacted to combat a long history of suppression of minority voting rights. To make the law work, Congress enacted a test that turns not on proof of discriminatory racial motivation or purpose. That's hard to do. It's hard to get inside the heads of legislators. So Congress enacted a law that turns on discriminatory results. The statutory language that it enacted is a mouthful, so I'm going to cut to the chase. The Voting Rights Act gives equal opportunity to members of a racial group to elect representatives of their choice. Before the Calais decision, assessing what equal opportunity means in a case like this required plaintiffs to show 3 things, and here I do have to go into lawyer speak. First, whether it was possible for the state to draw an additional majority African American district under traditional districting principles, which generally entail geographical compactness, not splitting up cities. That's the traditional way that district lines were drawn. The second thing the plaintiffs had to show was that African American voters were politically cohesive. That is, they typically voted for the same candidates. And the third thing was that the majority racial group voted as a bloc to defeat the minority. That was the threshold that Congress wanted to be addressed. Then it went on to ask courts to look at the totality of the circumstances to determine whether it was discriminatory for the state not to add another district. This was a very hard test to meet, but it was designed to root out discriminatory practices that locked minorities out of the political process. And it worked. For many years, it succeeded in unlocking political power for racial minorities, Hispanics, and African Americans throughout the country and greatly increased their participation in representative bodies. All right, let's go back to Louisiana now. Recall that in Louisiana, African Americans composed 1/3 of the population, but the state's map divided them between districts so that they could elect only 1/6 of the congressional delegation. African American plaintiffs successfully challenged the Louisiana map as a violation of the Voting Rights Act. Louisiana was ordered to draw a new map with 2 majority African American districts, and it did that. But then a new group of self-described non-African American plaintiffs emerged to challenge that map. They argued that a map with 2 majority African American districts was unconstitutional. Why? Because the non-African American plaintiffs said the map was impermissibly based on race in violation of the Equal Protection Clause. In other words, using race as a remedy for discrimination throughout history was itself discriminatory, they said. And that is the claim that ultimately prevailed in the Supreme Court. The court got to that result by, to use the court's own words, updating the Voting Rights Act. I would put updating in quotes. In reality, as Justice Kagan wrote in dissent, the majority destroyed that venerable act. The court did so by placing an impossible burden on minority plaintiffs to establish a violation of the Voting Rights Act. They essentially had to disentangle block voting by race from block voting based on politics, because the Supreme Court had held in an earlier case that political gerrymandering cannot be challenged in federal court. Yes, your legislators can draw maps that entrench their own political party and lock the other political party out, and the court has said that is fine. The result is that under the court's interpretation of the Voting Rights Act in Calais, African-American voters had to show not only that they voted as a block and that they could be put into a district in which they could elect a representative, but that if the state's goal, avowed goal, was to elect a Republican, they also had to show that that district would elect a Republican. So the upshot is that if the state claims that its map is designed not to harm blacks, but just to help Republicans, voting rights plaintiffs have to show a logical impossibility. And if you think I must be kidding, let me quote from the Supreme Court's own opinion after Calais in a case involving Alabama. Alabama sought relief from an injunction requiring it to create an additional African-American district. The Supreme Court obliged Alabama's requests. Alabama's plan, the court said, was not barred by the Voting Rights Act because, and here I am quoting, the mere fact that voters of different races vote for different parties is not relevant to proving racially polarized voting patterns. But that is exactly what the phrase racially polarized voting patterns means, that voters of different races vote for different parties. So where does Calais leave us? The Voting Rights Act helped to fulfill one of the key promises of the post-Civil War constitutional amendments, to create a nation of equal citizens. Only by protecting the right to vote can the nation ensure that minority communities have a voice in government, and only by safeguarding the vote can Black citizens fully participate in political life. Yet the Calais court saw things differently. The court seems to believe that the positive strides made under the Voting Rights Act mean that the act is no longer needed. Justice Ruth Bader Ginsburg gave the definitive answer to that logic in her dissent in a 2013 voting rights case called Shelby County versus Holder that invalidated a different portion of the Voting Rights Act. The court's reasoning, Justice Ginsburg wrote, is like throwing away your umbrella in a rainstorm because you are not getting wet. Now, I have to say, given the weather forecast, I was originally planning on including a joke in here. Don't throw away your umbrella, but we got lucky. The tragedy here is that voting rights are vital to knitting together a pluralistic society into a cohesive whole. As the Supreme Court wrote in another famous case from the 19th century called Yickwo versus Hopkins, voting is, quote, the fundamental political right because it is the preservative of all rights. I hope, by the way, that you all do plan on going out and voting in the midterms. Yes? Thank you. Because without effective representation, minority communities and really all of us are vulnerable to being marginalized in governance and in protection of rights. Now, I want to turn to my second example of how the Supreme Court said that being part of the national community as a citizen does not necessarily mean recognition in the community. This is a case from a very different realm from voting, but it involves a comparably sacred part of American life: sports. Growing up in West Virginia, Becky Pepper Jackson, yes, another Jackson, realized from a very young age that she was transgender, born as a biological male, but knowing that she is a girl. Her family supported her gender identity, and she took puberty blockers and hormonal treatments to align her body with her gender identity. And like many young people, she yearned to play sports. When she entered middle school, She wanted to try out for the girls' track and cross-country teams. But West Virginia had a different idea. Since 2016, West Virginia had a policy allowing transgender girls to participate on girls' teams on a case-by-case basis if their schools found that fair competition would not be impaired. If an opposing team challenged a transgender girl's participation, a state board would determine whether allowing her to play would jeopardize competitive equity or player safety. But in 2001, despite the fact that no transgender girl was playing on any girls' sports team in West Virginia, the state enacted the Save Women's Sports Act, categorically banning transgender girls from girls' teams. Becky sued, and she won a preliminary court order, allowing her to compete on the track and cross-country teams. As her mother recounts, Becky had the time of her life, making close friends and working hard at her sports skills. But her lawsuit against the state continued, and the state found ultimately a receptive audience in the trial judge. The trial judge did not resolve Becky's factual claim that puberty blockers and hormonal treatments meant that transgender girls like Becky did not have a competitive advantage or pose a safety risk by having been born a biological male. Instead, the court said West Virginia's categorical judgment to separate school sports teams based on sex assigned at birth was constitutional because the law was substantially related to the state's interests in protecting the fairness in sport and the health of the players. The Court of Appeals, sitting in Richmond, Virginia, reversed, but the Supreme Court ultimately granted review, and in its 6-3 decision in West Virginia versus BPJ, Justice Kavanaugh wrote an opinion upholding the West Virginia law. Justice Sotomayor, joined by Justices Kagan and Ketanji Jackson, dissented. Now, the contrasting visions of the majority and the dissent speak volumes about how the Supreme Court protects the rights of citizens to be treated as individuals by their state. The crux of the dispute between Justice Kavanaugh, as in his majority, and Justice Sotomayor's dissent is how precise the state has to be in drawing distinctions based on sex. For decades, the Supreme Court has applied what it calls heightened scrutiny under the Equal Protection Clause to laws that classify based on sex. We have Ruth Bader Ginsburg to thank for that development in the law. She achieved it when she was an advocate for the ACLU before joining the court and writing opinions that deepened that fundamental principle. Under it, courts look closely at sex-based classifications because of the risk that the state has relied on outmoded gender stereotypes rather than legitimate justifications. Under that approach, the state can't simply say its discrimination based on the sex is rational or reasonable, as it can do for drawing lines in regulating business or the economy. Rather, the courts stand guard against sex stereotypes by requiring that a classification be, quote, substantially related to an important governmental objective. This requires courts to look closely at evidence and logic before accepting a sex classification. And under this test, the court, for instance, struck down laws that barred women from serving on juries or barred women from applying to Virginia Military Institute, a formerly single-sex military academy. In BPJ, no one doubted that in general, separating sports by sex is fine. Men in general have biological advantages that would undermine competitive fairness or pose safety risks if boys could try out for girls' teams and participate on them. But for Justice Kavanaugh, that was enough. That generalization, he said, did not have to be perfectly applied to transgender girls, only substantially related to the state's goal. So if the sex-based distinction is valid in most cases, that is the end. The state need not consider whether an identifiable class of transgender individuals qualify for an exception because they as individuals do not pose risks to competitive fairness or safety. And again, Becky claimed she was that person. Puberty blockers and hormonal therapy had eliminated competitive advantage that she might have had from being born as a biological male. But for Justice Kavanaugh, that didn't matter. Justice Kavanaugh deferred to state political processes to sort out claims about the conflicting science surrounding transgender girls and sports. He regarded the Constitution as silent. For Justice Sotomayor, however, Becky's claim very much mattered. At the heart of the equal protection guarantee, Justice Sotomayor argued, was the right to individual consideration in this context. Let Becky be heard, she maintained, on her claim that she belonged to a class of girls for whom a rigid biological rule is a misfit. Justice Sotomayor stopped short of saying that Becky should be able to play, but she argued that a court should resolve the facts underlying her constitutional claim to equal treatment. She should have a chance to prove what the state denied, that her participation on girls' teams would not harm competitive fairness or pose safety risks. Now, Justice Kavanaugh responded by acknowledging that, like other girls, the transgender girls involved in these disputes want to play sports, and he said, their desire to compete warrants respect. Justice Kavanaugh, an ardent sports fan and a girls' basketball team coach, well aware of the many benefits of participating in sports for all young people. But he effectively said to Becky, we see and hear you, but the state doesn't have to. That is a surprising development for a court that said just 3 years ago, and here I am quoting, at the heart of the Constitution's guarantee of equal protection lies the simple command that the government must treat citizens as individuals, not as simply components of a racial, religious, sexual, or national class. The court said that in SFFA versus Harvard College, the case that ended race-conscious admissions in higher education. The court's decision in BPJ, in my view, took a step backward from that principle. In deferring to the legislature to decide questions of equality in sports for female transgender athletes, and in denying Becky the opportunity to prove her competitive fit, the court said to Becky, what is good enough for boys as a class is good enough for you, despite Becky's status as a citizen entitled to be treated as an individual, in the words of SSFA, not as simply a component of a sexual class. So stepping back, the court's decision in West Virginia versus BPJ is another example of the flip side of the birthright citizenship case. In reaffirming birthright citizenship as a constitutional principle, the court was generous in saying who qualifies for the priceless gift of American citizenship. But in other cases, the court effectively said that making it through the citizenship door does not necessarily guarantee full rights within the American community. And here I want to turn to insight to Justice Robert Jackson. In 1943, Jackson wrote for the court in a different case involving a student in West Virginia's public schools, the celebrated flag salute and Pledge of Allegiance case, West Virginia versus Barnett. In some ways, Barnett is the quintessential statement of what American freedom means. And it sends a message of inclusiveness and respect for individual rights that is missing from the rulings that I just discussed. Barnett involved a West Virginia law that required public school children to salute the flag and recite the Pledge of Allegiance. The children of Jehovah's Witnesses refused to participate because of their faith. Their religion taught that the Bible forbade them from bowing down before any graven image, here in their view, the American flag. West Virginia's law threatened serious consequences. It provided that a child's failure to salute the flag constituted grounds for expulsion and being sent to a reformatory. The state could prosecute parents for causing delinquency. Walter Barnett and 2 other parents brought a class action challenging the law as an infringement of Jehovah's Witnesses' right to practice their religion, and a bold district court granted them relief. West Virginia appealed to the Supreme Court. Now, Barnett did not come to the court on a blank slate. Just 3 years earlier, in a case called Minersville School District versus Gobitis, the court had held that states could compel students to salute the flag and pledge allegiance as a means of instilling patriotism. The court rejected the Jehovah's Witnesses' bid for a religious exception as asking that exceptional immunity be given to dissidents, which would inject elements of difficulty into school discipline. The court just thus announced a categorical legal rule upholding a state policy that allowed no exceptions. When the Jehovah's Witnesses returned to the Supreme Court in Barnett, they again based their claim primarily on the freedom of religion protected by the First Amendment, the same claim that had lost just 3 years earlier. But Justice Jackson, really in an illustration of his deep American values and his genius, reached for a broader rationale to uphold their rights. He wrote for the court that the state lacks power to compel anyone, not just religious objectors, to engage in a flag salute and a pledge so touching on matters of opinion and political attitude. He described the realm of belief as a sacred and inviolable space that protected all children against compulsion to salute the flag for whatever reason they may wish not to do so. Jackson did not dispute the important interest in national unity that West Virginia sought to foster. What he did dispute was, quote, compulsion as here employed is a permissible means for its achievement. And here another aspect of Jackson's genius comes into play, his understanding of the sweep of history. Jackson wrote, those who begin coercive elimination of dissent soon find themselves exterminating dissenters. Compulsory unification of opinion achieves only the unanimity of the graveyard. Clearly, the events unfolding in Europe in 1943 with what he described as our totalitarian enemies weighed on Jackson. This made his willingness during World War II to strike a blow for individual conscience against a patriotic ritual all the more striking and courageous. But Jackson perceived that liberty in America is the right to differ as to things that touch the heart of the existing order. And he concluded it with one of the most inspiring passages in all of the Supreme Court's writings. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. Now, last night I saw a videotape of Mark Russell setting those words to music and singing them. I wanted to do that for you today, but I decided to spare you. So what lessons can we draw from Jackson's opinion in Barnett? He confronted a very different problem than in BPJ, the protection of all citizens against coercion of expression and belief. And he faced no problem of what some see today of arguably conflicting rights between girls participating on girls' sports teams and transgender girls who want to join. But Jackson's underlying views about what knits the United States together reflect a spirit of inclusiveness. The fact that schools are educating the young for citizenship, he said, is reason enough for scrupulous protection of the constitutional freedoms of the individual. And this unqualified endorsement of a student's right to participate in public schooling on her own terms stands in marked contrast to the BPJ court. BPJ upheld West Virginia's categorical ban on transgender girls participating in girls' sports, regardless of the facts. Justice Jackson adhered to a different philosophy. He placed stock in facts. He once wrote that unless we, the court, are to reach judgments as did Plato's men, who were chained in a cave so that they saw nothing but shadows, we should consider the facts of the case. And he placed stock in courts. In Barnett, he wrote that one's right to life, liberty, and property, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. Rather, Justice Jackson said, the responsibility to protect constitutional rights falls to courts. This did not mean that Jackson thought courts had all the answers. He recognized that we, the court, act in these matters not by authority of our competence, but by force of our commissions. But he did not shrink from deciding the hard questions because they are hard. There is no way to know how Justice Jackson would have decided the questions the Supreme Court faced this term: how to give African American citizens a voice in voting, what rights transgender girls might have to play on public school sports teams, were not on the court's agenda when Jackson served. But Jackson's opinion for the flag salute case shows great solicitude for individual liberty within the national community. Perhaps he would have seen the right of individual transgender girls to participate in school sports as worthy of respect. And if so, he might have agreed with Justice Sotomayor's dissent that this discrete class of individuals should be heard and given the chance to show that for them, the state's categorical ban of participating on a girls' sports team was a denial of equal protection. And in Calais, the voting rights case, perhaps he would have vindicated the pivotal role of that law in weaving America together into a single society, a single democracy, after decades of suppression of minority voting rights. There is no question that Jackson understood the legacy of racial discrimination in American life. We have one significant data point about his views. Justice Jackson joined Chief Justice Warren's unanimous opinion in Brown versus Board of Education, which we've touched on today. But he struggled with his decision, leaving behind in his papers a draft concurrence revealing that he thought segregation was wrong, but he had to work through the issues to find a legal ground to invalidate it. He was not persuaded that the drafters of the 14th Amendment in 1866 intended to abolish segregated schools. The District of Columbia had them. But he was, he wrote, and this is a quote, convinced that present-day conditions require us to strike from our books separate but equal. His decision to join the unanimous opinion by Chief Justice Warren and not to publish his draft concurrence sends a clear message. He envisioned the role of the justice and the role of him as a member of the court as to recognize injustice in present-day conditions and take steps to right it. Even if we cannot project Justice Jackson's views onto the present moment, we can still take inspiration from his judicial approach, his willingness to embrace individual rights, his ability to take an unflinching look at contemporary realities, his courage to reach rulings that furthered the nation's highest aspirations to the equality of all individuals. Where does this leave us in thinking about the court today? The court is far from infallible, but it is also not necessarily final. Things can change in the court's thinking, sometimes quickly, sometimes over generations. Barnett overturned Gobitis after only 3 years, a remarkably fast correction of a mistaken decision upholding the compulsory flag salute by an 8-to-1 vote. But it often takes longer. Plessy versus Ferguson, upholding segregation under the 14th Amendment, was decided in 1896. The court's journey to Brown versus Board of Education took a painful 58 years. But the court ultimately did reject Plessy, even if 2 or 3 generations lived through its deeply unequal regime. If the 250 years since the Declaration of Independence tells us anything, it is that realizing the ideal of equality takes time. If we are to draw inspiration from Robert Jackson today, as the tradition of this lecture attests, it is that the Supreme Court, as custodian of our Constitution, can move forward and right earlier wrongs. The court may not move in a straight line, but we can hope for future generations that over time, it will move in the right direction towards liberty and equality. Now, I will close my thoughts about the court with a quote from James Madison's defense of adoption of the Bill of Rights. Madison wrote, "If these rights are incorporated into the Constitution, independent tribunals of justice will consider themselves in a peculiar manner the guardians of these rights. They will be an indispensable bulwark against every assumption of power in the legislative or executive. The courts will naturally be led to resist every encroachment upon rights expressly stipulated for in the Constitution by the Declaration of the Rights." It is my hope that our Supreme Court lives up to that prediction. Thank you.
Thank you for your remarks, Michael. We are now transitioning to audience Q&A. We've got a little more than 10 minutes before the end of the program. If you are moving on to your next activity at Chautauqua, that's okay. We just ask that you do so quietly out of respect for those on the dais and your fellow audience members staying behind. You can still submit questions at questions.chq.org, which I am receiving right here on my trusty tablet. And those of you in person here in the Hall of Philosophy can submit a handwritten question. Just flag down one of our ushers. They are circulating now and can provide you a slip of paper and pencil. Michael, as you were speaking, we've got a number of questions that have already come in, and a handful of our audience members are wondering if you have an opinion on whether the current court, and maybe based on the cases and the rulings that you cited, has the current court permanently impaired the credibility of the Supreme Court?
So I certainly hope that the Supreme Court as an institution lives through some of its darker moments and emerges on the other side as the institution that it is designed to be in our system of government, a counterweight to the legislative and the executive branch, the political branches, one that is designed to look to the enduring features of the Constitution and protect them. Now, we are obviously living through an era in which fears of politicization of the court and of partisan judging have undermined the court's credibility. And there is only one way to regain credibility. The best way is not to lose it in the first place. But to regain it over time, the court has to demonstrate that it is above those accusations and that it is fulfilling its role as guardian of the rule of law. I recently read that Justice Kagan, appearing at a judicial conference, pushed back hard on the idea that the court is a subservient entity to the Trump administration. And I certainly think that that is true. There were at least 4 significant decisions this term in which the court pushed back on the Trump administration and rejected its claims. The birthright citizenship case was prominent. The case rejecting Trump's tariffs was very significant. The case limiting the ability of the president to fire a member of the Federal Reserve Board, Lisa Cook, represented a pushback on the administration, and so did the court's ruling not allowing the National Guard to be deployed in American cities to enforce immigration laws. So there are clear signs that the court is fulfilling its function, but the court is, in many ways, a reflection of our society. If we are a polarized, politicized society that doesn't agree on very much, and justices are appointed by presidents who appoint them for political reasons, and confirmed by a legislature which similarly acts politically, then it is going to be very hard to completely disentangle the court from a political perception.
You describe the Supreme Court as the custodian of our Constitution, but by lifetime tenure and selective retirement timing, they are locking in particular views. How can we, the people, better take ultimate charge of constitutional interpretation?
That is a great question, and it's probably not one that has an answer that any of us would like. The people don't really have that much ability to influence the way that the Supreme Court interprets the Constitution, given the slow turnover of membership on the court and the inevitability of political appointments. And we saw some low points in that in the end of the Obama administration with the blocking of Merrick Garland's appointment, and then the very rapid confirmation of Amy Coney Barrett. The only path forward is to build a society that has a greater sense of loyalty to Constitution over party. And that sounds very, very idealistic, and I don't want to be accused of promoting something that is not particularly realistic in our current environment.
From we the people to our representatives in Congress, this person asks, is there any law that Congress can pass, short of a constitutional amendment, that could help to rein in what appears to be an overpowered Supreme Court in the 21st century?
So there's a lot of debate about court reform and whether court reform is a good idea, and if so, how to do it. People talk about term limits. They talk about expanding the size of the court. Congress can pass laws that would restrict the jurisdiction of the Supreme Court to decide cases. I take a longer view on this than some. Over the long sweep of history, and not just in this country, but in other countries, courts have stood as guardians of liberty when the political branches have failed. And in the short term, we may not be happy, I may not be happy, you may not be happy with some of the significant decisions, and it may seem that the court has arrogated to itself too much power and has rendered decisions that we don't like. Nonetheless, impairing the ability of some institution in our society that has as its ostensible mission, and I think all the justices believe in it, as trying to do justice under law, it'd be a serious loss if that kind of body faded from history or was given no power. And if we look around the country and we see, around the world, and we see other countries in which Supreme Courts have been made tools of the political branches, often because of some of the criticisms that are made here, in the long run, I don't think that that will serve people's rights as well as an enduring constitution and a court with the authority and responsibility to enforce it.
We have a number of audience members who are wondering about your opinion on the increase in the use of the shadow docket in recent years.
So the shadow docket is a product of litigants seeking emergency rulings before cases have wound their way through the courts. And it's gotten a lot of attention, both because of its catchy name and because the Trump administration, when it came into office, particularly in the second term, but also in his first term, promulgated a number of extremely controversial and legally vulnerable executive orders. These were promptly challenged, and judges around the country set them aside. Now, the way that the judiciary is organized, the lower federal courts tend to be a little bit more representative than the 6-3 conservative supermajority that sits on the Supreme Court, and the government knows that. So the Solicitor General of the United States, who we heard talked about earlier, would take cases up to the Supreme Court and ask the court to stop lower court rulings that had halted bold maneuvers of the executive branch. And in many, many occasions, the court obliged. It's a very difficult problem to solve because the court always has had the power to issue emergency rulings. Among other very famous cases, a case where Harry Truman seized the nation's steel mills and was challenged in doing so, went to the Supreme Court on a very fast track. And the court ruled against President Truman in that case, but did it on a quasi-emergency basis. I think the court is sensitive to the need to explain itself to the American people. You may not agree, but at least if you see what it says, you have a shot at understanding why it did what it did. And in many of the shadow docket cases, the court did not write. My sense is that the court has become more sensitive to that objection to its practice and is doing a little bit more to take the shadow docket out of the shadows. The Lisa Cook case that I mentioned, for example, that came to the court on the shadow docket. The court scheduled oral argument, and it issued a full written opinion at the end of its term. Similarly, the case that told the president he could not use the National Guard came to the court on the shadow docket, but the court requested additional briefing, and it issued a written opinion explaining its thinking. So this is a problem that won't go away, but hopefully will get a little better over time.
If you are comfortable putting on your pundit or prognosticator cap, several questioners are asking whether you anticipate any forthcoming changes to the Supreme Court, retirements, appointments, and maybe even by the upcoming or soon to follow the midterm elections.
That crystal ball I don't have. All the justices seem to be very happy where they are. Sometimes they change their minds very quickly. They don't tend to give advance notice of that fact, so we will all have to stay tuned.
Thoughts on the idea that court packing could solve problems on the current court?
Yeah, I'm not a fan of court packing either. Court packing is a short-term solution. It would basically be expanding the number of the justices from 9 to, say, 13, and then conveniently trying to allow appointments that would balance it out ideologically. There are so many political impediments to that actually working, but I think there are a couple of practical reasons why it's not a great solution. One is that, let's just say, Party X has control of Congress and the presidency, and it decides to pack the court. So it adds 5 justices. But then in the next election, things turn around, and Party Y controls the presidency and Congress, and it does not like a court that is packed with its ideological opponents. So it expands the court again. We could end up with, a court as big as this room, which might actually be a good idea. So I welcome all of you on our Supreme Court. But it tends to be a little bit self-defeating. I also think that it undermines what is an ideal, not always achieved, but I think is a worthy ideal, which is that the court is a stable, enduring part of government that should not be tinkered with lightly for political reasons. Once you really do lose the court as even having the impression of being a body above politics, it becomes harder and harder to get it back. And we talked about that in public perception. If you add to that institutional change that is driven by politics, then you undermine its ability to, I think, function as I would want a court to function in our society.
So before I ask our final question, I'll just point out that Kristen McMahon and team are tabling for the Jackson Center over here to my left near the Grove, and you are welcome to stop by and learn more about the Jackson Center if you don't already. Michael, our final question. What is your view on the Supreme Court not having an effective code of conduct limiting conflict of interest?
I think I, like many, think that the Supreme Court should be governed by an explicit code of conduct like all other federal judges and most other public officials. And the resistance to that, I believe, will be overcome in time. It would be an important symbolic step in helping to reassure our faith that they actually are deciding cases based on law and not based on conflicting interests. And I hope that you all can write to your congresspeople and recommend that they put pressure on the Supreme Court to adopt a code of ethics.
Thank you to John Q. Barrett and Kristen McMahon and the Robert H. Jackson Center for continuing this lovely tradition. And once again, Chautauqua, please help me thank Michael Dreeben.
Thank you. Thank you.